Welcome to the 5th episode of Called to the Bar, International Law Over Drinks, a series of informal conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are speaking off the cuff and without benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra, and today I'm joined once again by Dr. Tamsin Page, Senior Lecturer at Deakin Law School and my old sparring partner in all matters related to piracy. So today we are in fact flashing back to the origins of our friendship and professional collaboration by considering violence on the high seas, and particularly the law applicable to Houthi attacks on shipping in the Red Sea. In particular, in mid-June, Houthi rebels used a drone boat or uncrewed surface vessel packed with explosives to hit a Liberian-flagged cargo container vessel, the MV Tutor, in the Red Sea. Tragically, a crew member from the Philippines died in that attack, and the vessel has since sunk. This follows the sinking of another vessel, the Ruby Mar, in March. Nonetheless, the MV Tutor incident raises questions of the law of war crimes, the law applicable under terrorism suppression conventions, the law of self-defense in Western missile strikes on Houthi facilities, and our favorite topic, the law of piracy. Now, Tamsin, before we get down to sifting through all these potentially overlapping legal concepts, doctrines, and issues, first question as always, what's your drink?
Okay, so today I am once again drinking tea. It seems to be a theme for me, which anyone who knows me would know. Today's one is from Sri Lanka. It's a Vithanakande Estate Ceylon. So it's a black tea. It's a really rich flavor, very dark golden color. It's what you think of in terms of scent when you hear tea. It's very much a very traditional tea, and it's absolutely delicious. What are you drinking?
Well, snap. I'm having a straightforward supermarket shelf Dilma Ceylon tea with a tiny dash of milk, probably made a bit weaker than the mighty Ceylon leaf deserves, but this is my standard 2 in the afternoon pick-me-up is a weak Ceylon tea. All right, now, Tamsin, we've spoken about your path into academia in episode 2, gloriously entitled Security Council Shenanigans. So today I'd like to ask something different, which we might run through the next kind of round of episodes. What skill or skills did you learn outside academia that have been most useful to you inside academia?
As we are well aware, I have former life as a chef and pastry chef in fine dining restaurants. And if that taught me anything, it's how to plan and prioritize. There's always more work to do in a day than you have time to do it. And you'll end up with finding things that, you need to get done now and other things that you need to get done by 3 weeks from now. But if you don't start them now, they won't get done and all of those sorts of things. So that ability to look at my workload and categorize it as urgent and important, urgent but not important, important but not urgent, or not important and not urgent in this quadrant of when things get done, with urgent and important first, and then everything else becomes a bit fuzzier between the three, but usually urgent and not important after that, moving on to important and not urgent, and then eventually maybe getting to not important and not urgent at the end of that, or having them graduate into urgent to get them done. So it's that kind of time management. That's the biggest thing that I've learned. And it actually, makes academia really easy to understand that good enough is fucking perfect.
Yep.
And know what the standard of good enough is. And if you've got that, it's fucking perfect and move it on.
Yeah, it's a profession where a lot of people make the perfect the enemy of the good. And one of the things I've always appreciated about working with you is not only our mutual commitment to the idea that good enough is good enough, but I suspect something that also maybe comes from a chef's background. At a certain point, right, the meal has to hit the plate, go over the pass, and get out of the kitchen. You can't keep fiddling with it forever. There comes a point where you've just got to serve and get it out the door.
Exactly. And so knowing what the standard, if good enough is this publishable? As soon as you think it's publishable or thereabouts, or will become publishable with reviewers' comments, send it out to review. Stop working on it. Leave it alone. And all of those sorts of things.
Yeah,
Yeah.
yeah, yeah.
That
No,
that's the thing the biggest skill I've learned outside of academia is that sort of time management and that anti-perfectionism of is it good enough? If yes, get rid of it. And but also understanding, well, what is good enough is a variable standard depending on what you're doing.
absolutely. All right, look, time is, as always, as you just flagged, is our enemy. So let's get down to maritime matters. So when we look at an incident like the MV Tutor, there's a number of different legal lenses we can apply to the same facts. So I've suggested before we started recording that the easiest order to address them is probably going to be first to think about the terrorism suppression conventions and the application in particular of the Suppression of Unlawful Acts Against the Safety of Maritime Navigation Convention of 1988, or as Law of the Sea tragics like you and me tend to call it, the SUA, the SUA Convention. Then the law of war crimes in a maritime armed conflict, then the law of piracy, and then, time permitting, the law applicable to striking at insurgent or non-state actor groups in another state's territory. And I know that we're going to wind up contesting a whole lot of this terminology as we go through, but that's all part of the fun of the fair. So, Tamsin, would you like to kick us off with your take on the applicability of the SUA Convention and also the politics of calling it the Terrorism Suppression Convention in the first place?
Yeah. Yeah. So noting that I expect this will be a bouncing back and forth discussion because we are both experts in this area rather than me asking you questions later. This is where we both work and a lot of our collaboration sits. So I don't think there's no objections to calling it a terrorism suppression convention because it says it is that in the preamble, and it was drafted in response to a terrorist hijacking in the 80s, the Achille Lauro incident, because it was determined that there was a gap in UNCLOS and Geneva Convention on the High Seas piracy provisions in response to that incident. So go have a look at that incident, listeners. If you kind of want that history, it's not that important to what we're talking about now. But I don't think there's any issue calling it a terrorism suppression convention. There are lots of issues with the designation of terrorism, and there's a lot of political issues with that, particularly we've seen in the last couple of decades with the use of terrorism to deny belligerency rights to armed groups. And we'll get to that in a bit. And that question of terrorism also led to the 8-year disagreement that you and I had over the definition of private ends in the piracy law,
Right.
because we were looking at, you were looking, is it public or private? I was looking at, are they going to use, but they're terrorists, to abuse refusal
Right.
of belligerency rights? So
So
in
we,
response,
yeah, so we're already into that point where we've sort of indicated that there's just this big wibbly wobbly ball of overlapping concepts. I'm just going to try and tease out a few before we get stuck back into it. So the way I'd sort of characterize this is, as you say, the original maritime crime, in a sense, is piracy, and that's unlawful acts on the high seas committed by individuals for private ends. And we'll come back to the fuller definition. So that's on the one hand. But that's always, to some extent, been set against the category of what can you lawfully do during a war on the high seas on the other. And then, of course, we have the other bucket people like to put political actors they don't agree with into terrorism. So we have these categories of belligerency, piracy, and terrorism. And the question then for us as doctrinal lawyers is, well, what does the text of the law actually tell us about these, and where are the edge cases? So just to come back quickly to the SUA Convention and why we don't think that's particularly controversial on its face, is it grows out of that period of suppression conventions where no one could agree the definition of terrorism, but they could agree that certain tactics were bad, including, for example, taking hostages or blowing up ships. So if we look at Article 3 of the SUA Convention, Article 3.1c says, it's an offence to destroy a ship or cause damage to a ship or its cargo, which is likely to endanger the safe navigation of that ship. Now, I'd say blowing the ship up so that it sinks definitely endangers its safe navigation.
oh,
Right?
yeah, that's entirely uncontroversial, and noting that the preamble of SUA says it's a terrorism suppression convention.
Right.
So calling it a terrorism suppression convention, not an issue. For why I don't like the term terrorism, I'd like our listeners to go and read. It's a very short article by Austin Turk called The Sociology of Terrorism.
Right.
It's it's a good summary of why I don't like the term terrorism to begin with.
Okay, so we've got this sort of basic then framework saying on its face, sinking this ship by the Houthi rebels appears to be a crime that falls within the Sewer Convention. The question we've then got, though, is the carve-out. So Article 2 says the convention does not apply to a warship. So we are, in a sense, straight back into some of those questions around what constitutes a ship, what constitutes a warship, who gets to claim belligerent rights in an armed conflict, who is a legitimate combatant or combat actor. And that sort of maybe moves us over towards the war crimes discussion. But I guess if I can take the first stab at this one, my first thought on all of this is, in terms of the law of war crimes, we don't really have a problem here, right? Like, in the sense that even if, for technical reasons, the Sewer Convention doesn't apply, and
It doesn't.
We can come back to that. We can definitely come back to that. But even if it doesn't apply, what we've got is an actor in an armed conflict that has chosen to attack the merchant vessel, a civilian vessel of a non-party to the conflict. That is ipso facto a war crime, right?
Oh yeah, that one's. We don't even need to spend time on that. No matter how we fall on Sewer Convention, not applicable. You can disagree with me, but not applicable as far as I'm concerned. And I also take a little bit of offense at saying that we are doctrinal lawyers. I'm a sociologist. You can be the doctrinal lawyer.
Yeah, but you're one of the people who actually reads what the law says, Tamsin, as
this
opposed
is
to kind of
true.
like making sort of general speculation.
It's my
about the
burden and my
why.
curse.
Right. So this is why we get along. I take you seriously because you bother to engage in the textual interpretation within the socio-legal context. But
yes.
Okay, so tell me why I'm wrong and tell me why the Sewer Convention doesn't apply.
Well, the Sewer Convention doesn't apply because its carve-out is for a warship, state-owned vessel in form of naval auxiliary or customs or other policing purposes, or we have immunity of warships. And at the end of the day, if we actually look at the situation in Yemen itself, and I'm drawing up, I have on my screen over here the most recent data on the zones of control in Yemen from the UN Office OCHA. I can't remember what it stands for. Humanitarian Affairs, something or other. On zones of control, the Houthi control the capital and most of the major population centers in Yemen. So to say that they are just a terrorist group, I think denies reality, denies facts. You can disagree with them, and I'm not saying they're good people, but at this point in time, they are the de facto government of Yemen. Whether we accept that or not, they are the de facto government of Yemen, and if nothing else, that makes them belligerents to a NIAC, so non-international armed conflict, or an international armed conflict because they're engaging in this behavior on their claim as collective self-defense against Israel for what's happening in Palestine. Now, I have a whole bunch of questions about the validity of that claim, but at that point in time, them engaging in maritime activities falls under, is this an unlawful blockade? Is this attacks on civilians? Is this war crimes? It's certainly not terrorism.
I'm going to step us back a moment there, he said, handily taking himself off mute, because there is an assumption in your logic, which I think is found in the convention, that if it's an armed conflict, the Sewer Convention doesn't apply, or that it's the kind of armed conflict in which the Sewer Convention doesn't apply. So let me just step through that quickly. So the Sewer Convention, and this is a really interesting point, right? Because it's been put to me on occasion in things like the Mavi Marmara incident in 2010, which I believe we've mentioned in a previous podcast in passing, where an aid flotilla attempt to blockade run the Israeli blockade of the Gaza Strip. And once a student kind of stopped me in my tracks in a class by going, well, why wasn't the Israeli interception of the aid flotilla a breach of the Sewer Convention? And I just went, well, it actually took me a moment to think it through. And I went, well, as we've said, Article 2 says the Sewer Convention doesn't apply to warships, and that must really encompass the officers and crew of the warship, because that's the only way a warship has agency, but it isn't terribly express. And there isn't a carve-out clause for periods of armed conflict in the way that you have sort of optional carve-outs around, say, human rights treaties, where you might have the ability to suspend or modify certain provisions in armed conflict or times of emergency. There just seems to be this assumption that it doesn't apply during armed conflict. And to some extent, maybe they thought at the time of drafting, well, this is maritime affairs. All we need is the warship's exception, right? But so I've got sort of two questions that come out of that, in a sense, for you. Is one, I agree with you that at the least, the Houthis in Yemen are a non-state actor, and I say at the least, a non-state actor engaged in a non-international armed conflict. Now, two things to my mind fall out of this. The first is, do you get belligerent rights at sea in a non-international armed conflict at all? And that is, do you have to be a state actor in order to have rights of warfare at sea? So for the listeners, this is a genuine debate. You know, who gets to exercise lawful power at sea in an armed conflict? And the second one is there just an oversight here? Is there maybe sort of a gray zone where firing a weapon from the shore against shipping, in a way that would be a war crime anyway, could also violate the Sewer Convention? Why do we have to assume the Sewer Convention is completely excluded? So now, your thoughts on those 2 points?
Yeah, okay. So at the thing, whether or not I actually dispute the Yemen situation being a NIAC when we look at the fact that Saudi Arabia is involved. And so I think it's grown beyond Yemen into being an international armed conflict anyway. In terms of, I'm going to go to your second question first, because they launched a drone vessel loaded with explosives. And so the question is, do we characterize that as a ship?
Right.
Or do we characterize that as a very guidable torpedo?
Right.
In essence.
Yep.
And I'm actually really torn on this question. I don't think we can characterize it as a ship, because its entire purpose is to ram and detonate.
Yep.
However, there are also questions around, well, are drone vessels, ships be classified as ships under the warships sections of UNCLOS, because they don't have a crew.
Right.
By their very nature, they don't have a crew, and kind of don't have an answer for that. The easy one is, if we had a clear mothership that was launching the drones, then they operate as an auxiliary vessel to the mothership, and the crew is on the mothership. I think that solves that problem easily. I'm uncertain how this drone vessel was launched, whether it was launched from land or from another vessel.
Yep.
And so I'm not able to answer that one. But if it was launched from land, I think it becomes essentially a very guidable torpedo rather than a ship, which then brings up your question of, well, how does this exclude the Sewer Convention, because there's no warships involved? And I think that comes back to the preamble. For me, the preamble of Sewer goes into, this is about terrorism suppression, and terrorism by its very nature is private actors. Terrorism by its very nature is acts by private actors. They are not given the authority or legitimacy of a state actor or a belligerent, which is functionally a de facto state actor. And so if we accept the Houthi as belligerents to either a NIAC or an IAC, and we accept them as the de facto government over significant portions of Yemen, then these are not private actors.
Right. Okay, and that's going to be important when we come to debate piracy. But just to sort of put, I guess, where I come down on these things. So a couple of things we've hit here are, one, again, just sort of flagging for listeners, dispute about what makes something a non-international armed conflict or an international armed conflict. And that's a consequential distinction, because you have a wider range of belligerent rights in an international armed conflict. The paradigmatic international armed conflict is an armed conflict between states. The paradigmatic non-international armed conflict is kind of a civil war or insurgency situation between a state and a non-state actor on its own territory. The difficult cases are the ones where you have some kind of cross-border dimension, and you have entities that are disputed as to how state-like they are. And the Houthis in Yemen is the classic one. So do we say they are a non-state actor engaged in a non-international armed conflict, in which case their rights are limited, or are they an actor, a belligerent in an international armed conflict, in which case their rights are more expansive? You've made a perfectly rational case for why they should be considered sufficiently state-like for it to be international. I'd sort of say that, I still stray towards the non-international armed conflict characterization, because I believe in a NIAC, the only thing that is relevant is the status of the non-state actor. I don't think crossing a border has any impact on whether we should characterize something as an international armed conflict or not. And in terms of where we'll probably go later, the idea of recognition of belligerency, I just don't see that the Houthis are widely recognized internationally as having legitimate belligerent rights. But I completely take your point that they have territorial control and are effectively a state-like entity. That then gets us to the question about, okay, assuming it's an armed conflict, is the vessel a warship or not? And again, I'm a little bit on the fence here, because the definition of a warship under UNCLOS talks about it, under the UN Convention on the Law of the Sea, talks about the fact that the vessel has to be under military command. Now, I think that could be done remotely, right? If it's being directed by orders, that's under military command, but then also crewed. So the question then becomes, well, can you remotely crew a vessel? And I've gone in print saying it's at least conceivable that a vessel that is kind of continually monitored by humans, that is directed by humans at all times, could be crewed. And again, we can think of, there have been actual suicide attacks, famously kamikaze planes in the Second World War, by aircraft or vessels that weren't necessarily intended to return. So I think it's a little more edge casey. But again, even on my argument, for example, if you had some kind of set and forget predator drone that was simply programmed to look for things opportunistically, and I don't think this was that kind of drone, then I think that just would be a weapon system, right? It would just be a mobile mine, essentially. But yeah, a lot sort of turns on these questions of characterization. Tamsin, where do you think we're up to now? I'm just sort of trying to keep us.
I think we've agreed that this is definitely war crimes if sewer doesn't apply, and I think we agree on that. If this doesn't it doesn't meet, like, surpasses the threshold of when sewer is applicable because of belligerency and conflict status, then it's definitely war crimes, because it's intentional targeting of civilians of a neutral state, because it was Liberian flagged vessel, and to my knowledge, Liberia has no involvement in the conflict in Yemen and no involvement in the conflict in Gaza. So no matter how the Houthi are characterizing their involvement in this action, it's a war crime. That's kind of uncontroversial. So I think we've covered that. And I think
nothing, and I don't think anything magically turns on the Houthis saying they're randomly attacking vessels in the Red Sea in support of the Palestinian cause. Like, initially, they sort of had some kind of claim that they were only targeting vessels with links to Israel
connection,
but they now just appear to be striking completely opportunistically. So there's no argument that they are targeting.
And to my understanding, that there's no lawful blockade in place in terms of of blockading the Red Sea passage.
Right. So again, for listeners, if you were a party to the conflict somehow on Palestinian side, and you were lawfully a party to the conflict, you might have the ability to intercept at sea, for example, arms shipments destined to Israel. You might also attempt to set up a general economic blockade, but that has a ton of legal requirements that in no way have been satisfied.
And on the note of blockade, I'd recommend Phil Drew's book on maritime blockades if people are interested.
Yep. And we'll try and get all of this into the show notes when we finish. But also, if we look at the MV Tutor, a peculiarly academic name, which I just can't get away from, as I understand, it was carrying cargo out of Russia, right? So, potentially cargoes related to a conflict, but a totally different conflict. So in terms of the general principles of military targeting, that you can only target things that would serve a genuine military purpose or confer a genuine military advantage, there's just none of that.
Yeah.
So it is straightforwardly war crime stuff.
Yeah. So I don't think that that's controversial. I think that realistically we're up to talking about piracy, and I actually think that this is where the genesis of our disagreement over private ends needs to be unpacked.
Right. And so we probably need to start by being fairly clear about the definition of
I
piracy
think so.
in Article 101 of the UN Convention on the Law of the Sea, which obviously draws that definition out from the Geneva Convention on the High Seas, the work of the Harvard Codification Project on International Law, and before even that, the work of the League of Nations Expert Committee in the 1920s. Along the way, the International Law Commission got its fingerprints all over this drafting as well. You can see how long Tamsin and I have lived with this stuff. Anyway, the definition of piracy has come down to us from those historical antecedents, none of which is ancient, right? Like we're talking about people who started sitting down between 1920 and 1982 going, wouldn't it be nice if we had a standardized definition of piracy? But anyway, the definition that resulted from that process was: piracy consists of any of the following acts: any illegal act of violence or detention, or any act of depredation committed for private ends by the crew or the passengers of a private ship or a private aircraft, and directed, 1, on the high seas against another ship or aircraft, or against persons or property on board such ship or aircraft, or 2, against a ship, aircraft, persons, or property in a place outside the jurisdiction of any state. Now, couple of things to pull out of that before we get down in the weeds. It has to be committed by the crew or passengers of a private ship, and a government ship or aircraft cannot commit piracy unless the crew mutinies. So when we see things, and we'll probably come to the South China Sea dispute and violence between the Philippines and China Coast Guard later, when we see the president of the Philippines call that piracy, that is not strictly legally accurate. Well, it's not legally accurate in any sense. It's just that when things happen on the sea that we disagree with, we tend to resort straight to the label piracy. So the critical words here then become, if we sort of think through the checklist, have we got violence on the high seas? I think we're just going to have to assume that. We don't have enough geographic information, but I think you'd be pretty stupid to sail through the Yemeni territorial sea at the moment. Do we have an act of violence? Yes, we really, really do. Has it been committed by the crew of a private vessel? Well, we're going to have to sort of think about that. And has it been done for private ends? Okay, so Tamsin, kick us off.
Okay, so the genesis of our long-running disagreement that we resolved in about 2020 when we started writing a paper on submarine cables together is, what does private ends mean? And you came down in a very, very crude summary of, it goes into the is it public or is it private debate in international law. Public means it's a state-based act. Private is anyone who's not doing it on behalf of a state. Really simple one. I disagreed with you on that and kind of went with the middle ground approach of, it doesn't have to be the old school piracy definition of for financial gain, but it can't involve political motivations. I've walked that back and we've come to agree, but I came to that definition originally, and this was the genesis of our disagreement, because of the use of the word terrorism and the use of the definition of terrorism to exclude belligerency and the abuse of terrorism to create grey zones between domestic criminal law and IHL, and how that was a grey zone used frequently. Terrorism is a grey zone frequently used to deny people who we don't agree with, particularly in relation to the war on terror, all of the rights and protections of criminal law, but also deny them all of the rights and protections of IHL at the same time. And that was the basis of we can't just use a public-private dichotomy in our interpretation of piracy. It turns out you actually agree with me that belligerency wouldn't be piracy, was our general endpoint discussion here. And so I was willing to accept that political acts could be piracy if done privately in international law, public-private dichotomy. But then again, in this situation turns on, are these acts for private ends?
So yes, just to, I guess, summarize that from my perspective, we both encountered the typical debate about what does private ends in piracy involve as being structured around, usually it's either private or it's political, and therefore if it's politically motivated, that is terrorism, it can't be piracy. And that was how a lot of people framed what is the opposite of private ends. And I came to it with another sort of group of scholars going, well, no, I think in international law in general, the opposite of private is public. And when we look at things like the warships carve out for the law of piracy, that seems to reinforce that idea. So for me, it's piracy if it's not sanctioned by a state. States have a monopoly on violence and so on. But we both look towards this other concept that we've been talking about, belligerency. So, there are circumstances where, perhaps narrow, perhaps wider, where non-state actors have recognized rights and duties of international law in armed conflict. And for me, that was always the edge case, right? When are belligerents potentially pirates? So from my point of view, the way I took it was, and I think roughly we agree on this, as you said, from different directions, if what you have done as a belligerent is not justified by the law of war, then it's piracy. But if it is done in accordance with the law of war and you're a quasi-public actor because you're a recognized belligerent, then it's not piracy. And more or less, we landed in that same space. So here, I think we'd probably be pretty comfortable going, well, the Houthis have, again, it looks pretty war crimey, so it's not going to fall into the belligerency or political exception in the definition of piracy. The one question we've got, though, we still can't get away from having to come back to classifying the drone boat as being a ship or not, right?
Yes, but I also would like to back up, and I think that noting that public-private dichotomy, I think that I would classify it still as a public act because from my point of view, the Houthi are the de facto government. So in the same way that despite claims of warships boarding other ships being illegitimately being piracy, it's the same. It comes into that same category of might rhetorically call it piracy, but legally, I don't think you can call it a private act because of the de facto governmental status of the Houthi over majority of the population of Yemen.
Right. And look, I think that's a reasonable point of view. I don't think I agree. I think I'd sort of go back to there's a narrow exception for belligerence, and it only works for you if you stick within the law of armed conflict. And, that's fine. It turns out
and this is where I think we are at a point with Yemen and the Houthi that we saw in the Security Council in the 70s with Taiwan and Communist China. It hits a point where we have to accept that the official recognized government doesn't actually, in fact, represent the state at large.
Yeah. And look, we saw a different version of that play out when you and I were both working on questions of Somali piracy, right? Because you had territorial entities like Somaliland and Puntland that didn't regard themselves as formally as part of Somalia, and in some cases were significantly better governed and more stable and more state-like than the rest of Somalia. But the international community wasn't prepared to countenance the breakup of Somalia into smaller territorial entities. So for the purposes of international meetings, they would go as a joint delegation called, the federal government of Somalia. I don't see that happening, obviously, in the Yemeni case, but it is interesting the extent to which that sometimes recognition isn't accorded to these state-like entities just on the basis that existing states don't like the idea of secession and disintegration of states.
And we've been seeing that in Afghanistan with all the withdrawal of the coalition forces and the Taliban taking control of how do we deal with the fact that we've been saying that they're terrorists for 30 years and now they are the government.
Right. We still have to get back to, though, the question of, could the drone boat be a ship for the purposes of the definition of piracy? Because that's another point where
that's another sticky point, and maybe.
Yeah.
It's about the best I've got is maybe.
Mm-hmm. Well, I think so. Again, the interesting thing about ship and vessel is that the terms are used interchangeably throughout the UN Convention on the Law of the Sea without a definition. And while we've said that a warship needs to be under command and crewed, there is no equivalent definition in UNCLOS. And essentially what everyone in the law of the sea who tries to come up with a definition of ship comes up against is the fact that the definitions vary from convention to convention. So something might be a ship for the purposes of, say, an International Maritime Organization safety convention, but not necessarily for the purposes of another instrument.
And this is where we come back to the sewer. So Article 1 defines ship under the Sewer Convention, and I quote here, "For the purposes of this convention, ship means a vessel of any kind whatsoever not permanently attached to the seabed, including dynamically supported craft, submersibles, or any other floating craft." So under sewer, it would be a ship, but we're not so sure about UNCLOS.
Right. So exactly. So you've got this position where I think it would be pretty uncontroversial to classify a drone boat as a ship under some conventions, like the Sewer Convention, as you've just mentioned. But what do we do with the very general definition under UNCLOS? I don't think I can go a lot further than your maybe. The thing I'd say that most people who've done a serious study of the definition of ship as a general concept come down to is ships, exist for one or both of transport and navigation. So obviously a ship has to be able to navigate, it has to be able to move through the water. So that is an essential characteristic. The question then is whether the ordinary meaning of ship also includes this idea of transport. Does it have to transport people or goods? Now, if the only essential element is navigation, then I think a suicide drone boat could fit. But if transport, and I don't think transporting a payload to target falls within that usual concept, right? It's normally about moving people and goods. So if both of those usually common elements are required, I don't think it's piracy because we don't got a ship.
Well, and the question also becomes is how important is the capacity to be registered for a ship? If a drone boat is not capable of carrying a flag state registration, can it be a ship? Or does it just immediately become a stateless vessel, in which case we're back into, yes, it's piracy because stateless vessels by their very nature can't engage in public acts. And
hold
that's
on,
just
hold
doing
on to your
my head in.
hats. Hold on to your hats, listeners. We're up against one of my favorite geek out subtopics, the nationality of ships. I've been preparing for this moment my whole life. No, not exactly, but close. Okay, so what Tamsin has raised as a potential defining characteristic of a ship is, does it have nationality? Now, the way we normally put this would be, is it flagged somewhere? Does it have a right to fly a flag? However, if we look at Article 91 of the UN Convention on the Law of the Sea, it says, every state shall fix the conditions for the grant of its nationality to ships, for the registration of ships in its territory, and for the right to fly its flag. So there are two things there. So often we'll go, well, if it doesn't have paperwork, if it hasn't been registered in a state, it can't have a nationality, and therefore it can't be a ship, or at best, as Tamsin's put it, it's a stateless vessel. Not so, dear listeners, because the second limb is the right to fly its flag. So a lot of states will say that for, say, pleasure craft, yachts, you might not need to formally register small boats. They will just have the nationality of their owner. So you can actually only resolve that nationality question if you know something about, unfortunately, the maritime law of Yemen and whether they think small craft automatically enjoy their nationality.
And not just that, the maritime law of Yemen under Houthi-controlled leadership and whether or not they think the drones have the right to carry their nationality and flag.
Right. So now we really are super deep down in the weeds in a way we normally try to avoid in this podcast. But I'm sorry, if you're still listening, this is just how we roll when we talk law of the sea. So I think what we've come to is, the bottom line here is there are a lot of barriers potentially to calling the kind of suicide drone boat a ship. We have said, though, that a lot of the definitions of ship are quite expansive. It could perhaps be a ship if all that's important is navigation rather than a transport function. But one could then ask, can it really have the status of a ship if it's not registered? And I'd come back to what you said, Tamsin. I mean, the concept of a ship without nationality suggests that you don't really need a nationality to be a ship. So for me,
I would agree.
So I think then for me, the critical question is the ability to navigate enough? If that's the core definition of a ship or vessel, then maybe you're over the line. So then in terms of the piracy debate, if we do have a ship and we do have an attack on the high seas, we're back to our dispute about whether the Houthis are state-like enough that it counts as the wrongful act of a public authority, in which case it's not piracy, but it is a war crime. Or in my case, going, no, they haven't done enough to secure the rights of belligerency. And even if they have, this is unlawful. So it can be both a war crime plus piracy. So we both agree war crime, but the votes on piracy are Tamsin 0, Douglas 1. Should we move on to other fun stuff to do with
I think we should move on because we could keep talking about this forever, and that's just not going to be interesting for our listeners.
It's going to be great for us, but yeah.
Yeah. Yeah. Okay. So the last question we have is the law applicable to striking at insurgent groups in another state's territory. And oh boy, howdy, is this one a bit of a minefield. Let's go with minefield.
Yeah. I mean, it's the rabbit hole that only keeps going down. So look, let me attempt to kind of sketch this first for the non-expert listener, and then you can come in with whatever nuance you want and whatever I've got wrong. So obviously, the UN Charter under Article 51 provides a right of self-defense for a state if an armed attack occurs. Now, could a non-state actor project enough force to rise to the level of armed attack? I would say so, and I'd say state practice now supports that. However, there's also the prohibition in the UN Charter in Article 2.4 on uses of force against the territorial integrity or political independence of other states. So the problem case, as seen in, for example, Afghanistan, is what do you do with a situation where a non-state actor has attacked you in a way that would give rise to a right of self-defense, but they're present in a state which does not control them, that they are not acting on behalf of, where the territorial state's done nothing wrong? Can you attack them in another state, right of self-defense, or are you prohibited by the Article 2.4 prohibition on the use of force in international relations? The attempt to square that circle by the US, the UK, and to some extent other states has been to say, if the territorial state is unable or unwilling to prevent them from continuing attacking or presenting a threat, then we can use force against them. My problem with that position has always been, the unable and unwilling doctrine, is you're looking at the practice of a very limited number of states when the other 180, 190 odd members of the United Nations have literally no incentive to sign up to such a rule or an interpretation, right? There's an awful lot more states in the world that could legitimately fear that force will be used against them under a pretext based on an unable or unwilling doctrine than can project force. So there is no rational world in my mind in which the majority of states would sign up to that.
And I'm kind of with you on the fact that the unwilling and unable doctrine is an attempt to launder aggression.
Well, that's put with your customary clarity of thought and cut through. So we do have, though, the sort of awkward thing that we've had attacks on international shipping, and a peculiarity of the law of aggression and self-defense is that attacks on flagged merchant vessels can trigger the Article 51 right of self-defense. Now,
very much so.
Non-law of the sea lawyers find that a bit weird because attacking, for example, an individual national abroad can't trigger Article 51 self-defense, but ships are treated as a special case. They're not floating territory, but they are a special jurisdictional object attached to the flag state. So we can get over the Article 51 barrier, the right to self-defense.
And I think that our oil platform scale and effects armed attack threshold is easily met by these attacks on shipping. That one's also not a question. These are clearly of sufficient scale and effect to be considered an armed attack. There's no question there.
Yep. So what Tamsin's referring to, for anyone not familiar with the relevant ICJ case law, is the idea that for something to rise to the level of an armed attack that can trigger Article 51 self-defense, it has to be of sufficient scale and effects. And our cases for that are Nicaragua and the USA, and the oil platforms case between Iran and the United States. So we're all good for that. But then, so the The US, the UK, and others potentially have individual rights of self-defense, but then the US and the UK have struck at Houthi bases in Yemen. Tamsin, legal or illegal?
This comes back to how do you classify the Houthi? Under my classification as a de facto state-like entity in control of vast territory of Yemen, it is a valid form of self-defense provided it is proportional to the goal of preventing further armed attack against merchant shipping through the area, provided there is a nexus between the attacked vessels and the state exercising Article 51 rights.
That's neat. The other thing I'd sort of say, and I mean that not in the American sense of really cool, I mean in the sense of, very precise. And actually, that gets you past my sort of objection, which is, from my point of view, this is just a non-state armed actor present in the territory of Yemen, in which case, actually, it's very difficult to find an effective legal justification for striking back against them. And indeed, Tamsin, on your sort of view, if you're striking them because they're a state-like entity in control of territory, that's effectively recognition of belligerency.
Yes.
Which goes back and solves a number of the problems we had before about, do the Houthis have belligerent rights? Now, I think the US and UK would probably, on the one hand, go, ooh, nice, easy legal argument if we acknowledge them as a state territory, but then, oh no, we're not going to recognize them as belligerents. So I still think they're on unable and unwilling. The only other doctrine I could think that would perhaps help would be the old kind of Caroline concept, test of necessity. Like if you could see that they're about to launch, or they had just launched attacks from a site and they were liable to do it again in the near future, you could say that while this would normally be an act of aggression or an unlawful use of force, it was justified by circumstances of necessity.
And I agree with that. I still think that the simple answer, whether or not they want to recognize the belligerency, is that this is just literally a classic state versus state self-defense exercise, provided it remains proportional to that necessary, limited to the necessity of preventing future attacks on shipping.
Right. Well, and look, sainted Hirsch Lauterpacht, blessed be his name, would probably have agreed with you on a lot of that because he thought belligerency was an objective condition, and it arose as a question of fact, and then you had a duty to recognize.
And I would agree that belligerency is a question of fact, and I think that that's actually really well unpacked by our dear friend Rob McLaughlin in his recent book on the recognition of belligerency in armed conflict.
Terrific. Look, I think we're running out of time.
So I think so too.
Let's move to our wrap-up questions as we drain our cups of tea. Now, the traditional wrap-up questions have included, what are you working on at the moment? But I presume you're still working on a lot of the things we discussed last time.
Yes, I'm also working on a promotion application. So, I feel like I need to shower, which means I'm doing it properly.
Right. A number of members of the pod are working on promotion applications, and good luck to them all. But first off, do you have any further recommendations? We've been pretty liberal with recommendations.
Yeah, so I mean, to sum up my recommendations on why I despise the term terrorism as any sort of a legal concept, go read Sociology of Terrorism by Austin Turk. On belligerency, Rob McLaughlin has been doing some sensational research on that. He's my go-to. And on blockade, Phil Drew's got a book on blockade that's really solid. So that would be my broad recommendations. On piracy, I recommend you read Page and Guilfoyle, and that you ignore anyone who says that the definition of piracy starts with Cicero. They just need a good slap.
Yes, indeed. And this is one of the things that I think we bonded over earliest in our friendship, was the number of people who read the word piracy and just lose their mind. Just absolutely lose any connection to ordinary legal rationality because it's pirates. Okay, well, so we've asked about escape routes in a previous episode again, and you gave us a terrific rundown of your various hobbies. So our new wrap-up question, we've decided off air, is going to be, Tamsin, what would you be if you weren't an academic?
I mean, I'd like to say I've already been a chef, so I've been there, done that. I'd like to say I'd be a DJ or a blacksmith because they're hobbies I kind of love. But in all reality, I dare say I would have ended up like Lila Morgan from Angel and just been the soulless, working for demons, corporate lawyer out there, to make shit tons of cash with very little moral scruples, unfortunately. So I'm really glad that I didn't turn into that. It was a serious option through my legal studies, and I ended up walking it back in a moment of clarity, and I'm very pleased about that. But that's probably where I would have ended up, and I'm really glad I didn't.
Yeah, look,
So
I think most members of the pod all have kind of experience of having heard the siren call of private practice and then decided it just wasn't for us for any number of reasons.
yeah.
Um,
I
Tamsin,
have one question for you to wrap up.
oh, yep, okay.
What is your attire for our viewers?
Oh, right, yes.
Listeners, because they can't see you. They cannot view your sartorial elegance.
Well, today I am back in my custom high-waisted and braces-bound grey wool trousers that I got my local tailors to make for me. They've been really good winter companions. Been wearing a white shirt, a black waistcoat, and a grey and black herringbone jacket that I'm very fond of. So a fairly tweedy academic vibe, but I didn't even realize it until I got in today. I'm actually wearing a red and black tie I got from the Clingendale Institute, a think tank in the Netherlands, when I first went there to work with them on a piracy project.
There you
So
go. Isn't that fitting?
yeah, that fits in rather well. Okay,
Yeah.
well, everyone, thank you for sticking with us. Tamsin, thank you as always for joining me, and we will be back in a week. Bye bye.